Another interesting question under the appointments and removal power is the issue of independent counsels, which of course has in recent years been very much in the news. So Morrison v. Olson is kind of the original case involving the original independent original independent counsel statute. And under the Ethics in Government Act of 1978, the Attorney General would investigate some alleged impropriety or unethical action in government. The Attorney General would report to a three-judge panel, and then the three-judge panel would decide whether or not to appoint a special counsel to further investigate and to define his or her jurisdiction. Now, the whole independent counsel animal, as I'm sure have grasped in the recent debates over the Mueller investigation, is kind of a unique animal. I mean, normally the Attorney General, which is kind of the law enforcement arm of the executive branch in the federal government, if it's investigating a crime and it's determining that some crime has been committed, then there would be a prosecution of that crime in the courts by the prosecutors. But this original Ethics in Government Act determined that there might be circumstances under which the executive branch, the Attorney General, would potentially have a conflict of interest, and that it would be better if an independent counsel does the investigation and then either refers it for criminal prosecution or does something else. So that's why this statute was created, and you can see the idea of creating a kind of judicial branch check on whether this should be done or not. So in this particular case, Alexia Morrison was the independent counsel who was appointed to investigate claims made against Theodore Olson, who you probably know is now a famous lawyer who was working in the executive branch at the time, and there were claims made against him. So the independent counsel statute is challenged, and the first issue that the court looks at is, does the appointment of the independent counsel by this judicial panel, Congress or the Attorney General going to this judicial panel and the judicial panel deciding whether to appoint the independent counsel, does that violate the Appointments Clause? And the majority of the court, in this opinion by Justice Rehnquist, says, no, it doesn't. The independent counsel is not a principal officer, and therefore the independent counsel does not require the advice and consent of the Senate. The second issue was with the removal of the independent counsel. So the statute had allowed the independent counsel to be removed only for good cause, and the question is, does this interfere with the president's power over appointments, or does it generally violate the separation of powers? Again, I'm sure in the news, if you've been following the impeachment hearings, you've heard in some of the testimony this theme that you have these State Department officials who are testifying, and one point the Republicans kind of make out from this is the president has the ability to appoint or remove who the president wants to appoint or remove as an ambassador or something else. And an ambassador, a State Department official, serves at the pleasure of the president. And that's correct. The president can remove the person for cause or without cause, or simply because the president wants to appoint somebody else. So the question here is, if the independent counsel can only be removed for good cause, does that unduly hamper the president? And the majority of the court says no. The executive still has the removal power, and there's nothing implied in the Appointments Clause that suggests that removal has to be simply at will. So Congress could create a statute that has an office like this or a role like this in which removal actually has to be for cause. Now, Justice Scalia has a notable dissent in this case. Justice Scalia says this does violate the separation of powers. The president has all of the executive power, not just some of it. And he notes this theme that you certainly have heard in the Mueller investigation, that an independent counsel can become kind of an Inspector Javert, can kind of run amok, doesn't really have any accountability, Even a judicial panel like this can be partisan, and therefore the kind of whole idea of an independent counsel is really inappropriate. Again, not the majority opinion, but an important theme that you hear in these debates. Just to note, the statute that Robert Mueller was appointed under actually was a different statute. The mechanism for appointing independent counsels changed kind of politically since the Morrison v. Olson case. So the current rule allows the Attorney General, in the case where the Attorney General has, or if the Attorney General has been recused, the acting Attorney General, to appoint the special counsel, and the Attorney General's office makes a determination that the investigation would present a conflict of interest for the Justice Department and that it would be in the public interest to appoint the special counsel. And this procedure has a termination rule that allows the special counsel to be removed only under the personal action of the Attorney General and only for cause. And the cause could include misconduct, dereliction of duty, incapacity, conflict of interest, other good cause. So this was part of the debate about, first of all, should Jeff Sessions have recused himself? And then, having recused himself and then the independent counsel, Robert Mueller, having been appointed, were there grounds at all for removing Robert Mueller, or the frustration of some of the president and some of his supporters of the fact that he could only be removed under this rule for cause?